Okay, I think I'll get started. I'd like to welcome everybody. My name's Keats Boyd. I'm from Boyd & Boyd PC. Today we're going to be talking about estate planning and how some of the tax proposals over the last couple of years have made us believe that planning's never really going to be the same. Before we get too far into the program, I need to give a general disclaimer. The information I'll be sharing with you this morning is intended to be educational in nature. It is not meant to be legal advice for anyone's particular situation. I can only give you that legal advice if I sit down and understand your goals, needs, and objectives. Then I'm happy to do that type of legal advice. But what I will say is much of the information I'll be sharing with you today is likely going to be appropriate for many of you. But as I said, we're happy to sit down with you if you're interested to talk about your particular needs. Another thing I should point out is the state bar rules of many states feel that some of this information might be considered advertising, and so I just need to disclose that to you so that you're aware that we might be falling into that category. A little bit of background about Boyd & Boyd PC. It was started by my dad back in the mid-1970s. We are a boutique law practice. Our area of specialty is estate planning, estate settlement. We provide some trustee services. We help with some special needs planning, a lot of tax planning, and of other areas that are tangential to that. We do not do other practice areas like real estate closings, criminal law, divorce practice, or anything like that. We really just stick to our little niche. Our practice really is a family affair. My dad started the firm, as I said, back in the 70s together with my mother. They both worked the practice up, and over the years, some of my family members joined them. My sister, for many years, worked in the practice, doing a lot of the bookkeeping and accounting work. She passed away several years back, and but in the meantime, one of her sons has worked with us. We've had a cousin, my brother, works tangentially. I'll tell you about his practice in a second. My wife works in the firm. We've had a number of family members in the practice, and so we want to give it that family feel. And so one of our taglines is, we hope that you'll let our family help your family. And that is really important to us. The team members who are not family members, we try to treat them and make them feel like they are family as well. So my brother also has a firm. His company is called Asset Management Resources. His company does investment advising, financial planning, and so the two practices, the legal side at the law firm of Boyd & Boyd and the asset management resources folks, our two practices really blend very well together. If you have a need for estate planning, you may also wish to talk to Chris to just have an update to your financial plan to make sure that your financial affairs are going to work the way you hope they will. He offers everybody who attends our seminars a complimentary consultation. If you're interested in that, just let us know. We'll make sure that they reach out to you to arrange for something like that. They have offices. We share an office in Hyannis. They also have a presence in Boston, Nashville, Tennessee, and St. Lucie, Florida. So they've expanded significantly during the course of the pandemic, and they really do a wonderful job. We find many times we see couples, one spouse is the financial planner of the couple, the other one isn't so much so. And if there were a death or an incapacity of the spouse that does a lot of that financial work, having somebody else to come in to be that continuity, Chris offers that and does a great job with he and his team. We have received some recognition over the last little while. For the second year in a row, we were one of the top 3 firms in Cape Cod Times, Cape Cod's Best, both for law firms and for estate planning firms, so we're very excited about that. We also are listed as a top 10 estate planning attorney in Attorney in Practice magazine. And then finally, Martindale Hubbell, we've had a distinguished rating for over 30 years, all of which we're really quite proud of. So, we're trying to do the things that you might need, and we're getting that recognition locally and nationally for some of our work. I want to start with a quote, and I put a few quotes throughout the seminar today. This one was from David Lloyd George, who was the Prime Minister in the United Kingdom about 100 years ago. Death is the most convenient time to tax rich people. We saw a series of proposed legislation last year that really brought that point to be forefront in my mind. We had several tax proposals that would increase estate taxes, make death a capital gains realization event, and increase income taxes overall. And the result of that for some of our clients, had all of these proposals passed, we would have seen estate taxes or death-related taxes range for many families from as much as 60% of the estate to possibly as much as 103% of the estate. Think about that, 103%. Your heirs would not get an inheritance, instead they would get a tax bill from the federal government. So it's a significant philosophy that still is entrenched in our government, and we want to make sure that when you do an estate plan, that you're looking at a variety of tax consequences to make sure the wealth you've developed stays with you and your loved ones. So with that in mind, you want to look at an estate planning firm that handles a variety of solutions. The traditional ones, of course, your core planning techniques of wills, trusts, powers of attorney, healthcare proxies, living wills, things like that. If your estate is larger or if you're concerned about asset protection, you might want to take on some of the extra core planning techniques, things like limited liability companies or irrevocable trusts. You may want to make sure that the firm is aware of some of the newer techniques that are out there. Things like a contract to plan or the personal asset trust or the IRA inheritance trust. We'll be talking about each of these as we go through the presentation today. Finally, it may be important for you to make sure that your estate planner understands that it's not only about planning in Massachusetts, or if you're a Florida resident, only planning in Florida. We have to look at a multi-jurisdictional issues for every family depending on what the nature of their wealth is. If you have a home here in Massachusetts and another home in Florida, well, you have different issues because of that. If you're a Florida resident, your plan needs to be compliant with Florida law, which is a little different from the signatory requirements here in Massachusetts. I'm seeing more and more people have a presence out of the country. I have a lot of clients who have real estate in winter in Mexico. And Mexican law is very different than the United States law is how we pass wealth at death. You really need to have a will in Mexico. Now, many estate planners here in the United States, if they're making a will, would start the will out by saying, I hereby make this my last will and testament, and I revoke all prior wills. If you had a Mexican will and then met with me and I did something like that, I just revoked your Mexican will, and that could be a real problem. Now you've got a whole different slew of issues in Mexico to try to make your estate plan work correctly. So your estate planner needs to be looking at all of these issues and making sure that they're not complicating your affairs, but simplifying the affairs at death. So these are some of the things you want to make sure your estate planner has the background to be cognizant about. All right, next what I'd like to do is go through a series of objectives that we see most people have when they're creating an estate plan. We're going to go through 5 objectives. The first one of these is testamentary disposition. In other words, how do we pass our wealth at death? And I bet when we talk about estate planning, that's probably the first thing all of you think about, is how am I going to get my wealth to my loved ones when I die? And there's a series of tools that we can use. Probably the most common one that everybody would consider is a will. Now, wills are great insofar as what they do, but they're very old technology. I like to analogize a will to a Brownie camera. You know, I happen to have one. It was my aunt's when she was a young girl, and it's a neat camera. It takes a nice picture, but you know, when you think about it, that camera, you have to take the film out, get it processed. You know, you look through the lens and you're getting your picture, and you don't really know whether or not everybody's smiling when you snap the shutter. You don't know if somebody's going to be moving or if the camera's just not going to get the right picture. And then usually with Brownies, they're black and white film. They're not really color film. So you got to take the film, get it out to go process, get it back, and then you may find that the event you were trying to memorialize, you just don't have a good picture of it. So what you might do instead is take out your newer technology, your cell phone. You know, you've got that beautiful camera that works really well. It gives you color images. You can look at it instantly and make sure everybody was smiling, that nobody's moving. Or if it's not a flattering picture, you can take another one and get a better picture of that person. Or if you really want to do a special type of memorialization, you might do video where you can get action and sound and get a more comprehensive memorial of the event that you're trying to capture. So wills are like the Brownie camera. Other tools are more like the smartphone. The revocable trust at the bottom of the list is really our more current tool. It's something that really has only been applied to the everyday estate plan for about 30 or 40 years. It's not something that everybody has used for many, many years, although trusts have been around for centuries. They really have only been applied to the everyday estate plan for a very short period of time. So we want to talk about how trusts work, but before we get to that, I want to talk about the contract to plan. This is a relatively new tool that has only been in our law for a few years. It's an agreement, typically between spouses. Basically says, I promise to give everything to you, you promise to give everything to me, and we both promise to give everything to our agreed upon heirs. Why do you need that agreement? Well, if a spouse dies and the surviving spouse then remarries and puts everything into joint name with the new spouse, what's going to happen when the surviving spouse of the original marriage dies? Everything goes to the new spouse, not to the heirs. Or if there's a caretaker that says, honey, your kids don't love you, they're never here, I'm here every day with you, I love you, I'm your family now, give everything to me. And maybe because of undue influence, the client does something like that, and the kids get written out, which is not really your intent. So we want to make sure that you have something to protect the people that you want to leave things to. And that contract to plan is that tool that gives them a right to say, wait a second, something's not right here. Somebody's exercising undue influence. It was done by accident. The intent was that it would always go back to the original heirs, and that contract the contract to plan gives the kids the opportunity to enforce that. Joint property is a very common tool. A lot of people use joint property. But quite frankly, when you get to the point when you're talking about an estate plan and retirement, you really shouldn't be using joint property an awful lot. You really should be looking at it maybe for your automobile if you're married, and maybe your day-to-day bank account if you're married, but that's probably about it. I really don't encourage joint property, especially with a non-spouse. I really discourage joint property. Let's look at a couple of cases we've had over the years. We had one case many years ago where a woman wanted her house to go to one of her two daughters. And so just to make it simple, she said, well, I want to avoid probate. I don't want to have a long drawn-out process. I want to make it really simple for this child to get the house, so I'm going to put it into joint name with her. She signed a deed and had it recorded at the Registry of Deeds that made her daughter a co-owner, so that when she died, the house would automatically go to that child. Very simple. Well, everything was fine for a few years until the daughter's husband decided he wanted a divorce. And in the divorce, he's entitled to half of everything that his wife owns. That includes the 50% joint property interest in her mother's house. So he proposed that they sell the house so he could get his 25% out. And of course, that wasn't too good for Mom. Mom didn't want to lose her home. So I don't recommend it because of that risk. And if it were a creditor like a lawsuit, the daughter got into a car accident, was at fault, the creditor could force the sale, seize and sell the property, and the daughter would have nothing to say about it, and neither would Mom. So it was a real risk for somebody. Don't use joint property with a non-spouse. We had another case a few years later where a child came to us after his mother had passed away. Her will said, I want everything to go to my 3 kids in equal shares. Her oldest child was her son, and then she had 2 daughters. Now, when her husband had passed away, she found she needed a little bit of help. And so what she did was she said, I'm going to take the house and I'm going to sell it and move to a condo. And condos have all these rules. I just don't get all this stuff. Son, I need your help. Would you do me a favor and go to the condo association rules and make a vote for me and do the things that need to be done with the condo? And so in order to get that to happen, she put the condo into joint name with the son. As time went by, she found she needed a little bit of help paying the bills. So she said, would you help me out? Pay my bills, take care of managing the financial affairs for me. So she put the son on as a joint account holder for the checking account so that he could pay her bills for her. Eventually, she kept getting these calls from the stockbroker, and her late husband had been the guy who did all the financial management and always talked to the stockbroker. So she didn't really understand what the broker was talking about. So again, she turned to her son and said, I need your help again. Would you deal with the broker and find out if he's giving me good advice or not? I need your help. Let's decide, talk to him and find out if it's a good idea to sell this and buy that. And so she put him again as a joint account holder on the brokerage account. When she passed away, everything she owned was in joint name. Now, her will said, give everything equally to my kids. But because everything was in joint name, the will didn't matter. Everything went to the joint account holder, her son. Now, fortunately for his sisters, he was a good guy. He could have just walked away and kept it all. But he came to us and said, how do I get them their share? If I give it to them, I have a gift tax problem because it's more than the gift tax threshold will allow. It was only $10,000 at the time. So it was a very expensive proposition for him to just give it to his sisters. So what we ended up doing was we had to file a probate to petition a court to say, it's not really meant to be joint property. It was really put into a trust, and the trust says, the trust is like the will. Give everything equally to the kids. That's what everybody intended. It was never meant to be his property. We all agree, court, tell us we can do this. And aside from a lot of legal fees, to get to court to get the decision, the judge said, since everybody agrees, I'm fine with that, go ahead and do it that way. We got the right result, but it was an expensive proposition to get there, all right?
So the judge didn't have a problem with the government losing their gift tax?
Yes, because he agreed that it was a trust and that it was never meant to be really joint property, and that the terms of the trust said this constructive trust, Mom's intention was...
Trust, meaning
it wasn't a written piece of paper, it was just a transaction that Mom was saying, you don't really own it as a joint account holder. I'm putting you on it to help me out, and it's really supposed to go like my will said.
So they can do that, have a constructive trust based on intention?
It's possible. Facts and circumstances will dictate what the court will say. In this case, the court said, yes, everybody agrees, we're okay with it, so that's fine with us in this particular case. All right? So another thing that we want to make sure you keep up to date are your beneficiary designations for life insurance, retirement accounts, things like that. You know, basically, if you have a retirement account, an IRA, a 401k, a 403b, you can leave that to your loved ones by making a beneficiary designation, putting the custodian on notice saying, when I die, give whatever's left in my account to my spouse, my kids in equal shares, whatever it is you say. Similarly, with life insurance and annuities, you can say something similar to that. When I die, give the death benefit to my spouse, give the death benefit to my kids in equal shares. But it's important that you make sure you update this beneficiary designation and make sure that the custodian or the company has the right beneficiary designation on file. Years ago, we had someone pass away. He was about 88 years old at the time that he died. And his kids came to us and said, we just found this life insurance policy in the basement. And what we want to do is find out, is it still valid? And if it is, who's going to get the money? And so we wrote to the insurance company and said, hey, you know, this policy, is it still in effect? And if so, who are the beneficiaries? The company wrote back and said, the only beneficiary designation we have on file was with the original application. The person who got it when he was in his 20s named his mother as his beneficiary. Now, he was 88 or 86 years old when he passed away, and he had never updated it when he got married to name his wife. He never updated it to name his kids when his wife died. He never updated it to name his trust when he put a trust in place. All the things that should have been done along the process. So we ended up having to go through probate because his mother had passed away some 50 years earlier. So we ended up putting that policy through a probate proceeding that took a year before the kids could actually get that money. So you want to make sure that you've got the right beneficiary designation in place. Check with your insurance companies. Make sure it is what you think it is, all right? And if it's not, update it. Retirement accounts, we had a similar situation where we put a specialized trust in place to be the beneficiary of the retirement accounts. And in this case, we had actually mailed a beneficiary designation to the custodian and asked them to confirm that they received it and that they've put it in place. The company did that. They wrote back and said, yes, this is in fact the beneficiary. We're all set. Here's a copy for your records. We said, great. A couple of years passed and the woman passed away, and we went to implement the trust. So we wrote to the custodian and said, please confirm you still have that beneficiary designation in place. And they wrote back and said, sorry, we don't have any beneficiary designation in place. And we kind of said, what? What about back when? Oh no, there's never been a beneficiary designation. Well, we went out, pulled our file out, found the form that they had confirmed to us and sent it back to them, said, you gave us this, what's going on? Oh, well, we had a computer update a couple of years back, and when we did that, it must have dumped all the beneficiary designations that your client had put in place. Sorry about that, we'll honor the one that you sent back to us. So we were able to get the right result. But companies are doing computer changes and things like this all the time. So make sure that if you've got an IRA beneficiary designation or any kind of retirement beneficiary designation, that you check to make sure you have a copy of whatever it is the company has in place, so that if their computer dumps your beneficiary designation, you'll have the right the right beneficiary designation in place for your family. All right, the last thing I want to talk about here are trusts. Who will be the beneficiary? How do trusts work? Trusts are basically a contract, and we have three parties in this contract. We have a donor, the person who's going to create the trust and give property to it. We have a trustee, the person who will manage and own the property in the trust for the benefit of the third party, the beneficiary, the person who gets to use and enjoy whatever the trust owns. So we want to make sure that we've got all three of these parties, and we also want to make sure that you as the client can be all three of these parties. I mean, if you're going to create a trust and give away your assets to that trust, I know you're going to want to maintain control, and I also know you're going to want to be able to continue to use what you're putting in the trust. A revocable trust allows us to let you be all three. But in order to have a valid trust, we have to go a step further. We can't just stop here. If we do, the law says, well, there never really is any trust. There's no separation of the property, so it's not really a trust at all. We just ignore it. So to have a valid trust, what we do is we add a future interest beneficiary, someone to be the beneficiary after you. So it could be your spouse, it could be your kids, it could be your favorite charity. It doesn't matter. Whatever you want, we'll name them to be the successor beneficiary. All right? And in doing that, you have a valid trust. All right? And at the same time, you're accomplishing your testamentary disposition objective. You're leaving your assets that are owned by your trust to the people you want to have receive them. So it's all done within the contract. It's kind of like a beneficiary designation if you simplify it down. You know, it's really just saying, when I die, the beneficiary of my trust is my spouse. When my spouse dies, the beneficiary of my trust is my kids in equal shares or whatever it is that you want. Any questions on this so far?
What's the taxability issue?
We'll get to the taxes a little bit later. There's a lot of tax complications with this, but we'll cover that in one of our objectives, all right? All right, the next thing we should talk about is our second objective, incapacity care planning. How do we manage assets or make medical decisions if we can't make those decisions for ourselves? So we're going to break it into two parts, medical decision making, then we're going to talk about financial decision making if there's an incapacity. So we have a handful of tools available to us. The first one is a guardianship. This is a court proceeding. A guardianship, you have a court appoint someone to be in charge of the physical person. Who can make medical decisions for the person if they can't voice those decisions for themselves? Now, a court proceeding is a more expensive process. It takes time. It doesn't happen overnight. So I think the better approach is to make sure that you have something called a healthcare proxy. This is a document that is allowed by Massachusetts law. We passed this law in 1991. That basically says you can appoint an agent to make medical decisions if you're unable to voice those decisions for yourself. Now, if you can tell the doctor what care you want, that's going to control. But if you can't, that's when your healthcare agent will step in and make decisions for you. Now, if you don't have a healthcare proxy, we have them available for free on our website. You simply have to go to boydandboydpc.com, find our downloads tab, it's near the top of the page, and click on that. We ask you for your name and email address. You'll get invitations to seminars and newsletters if you want them, and you can always unsubscribe. But once you get that information, once you provide us with your name and email address, there'll be a long list of different things that are available for download, one of which is a healthcare proxy. So you download that, it's a PDF file, you open it up, you print it out, print in your name and address, appoint an agent, one person to be in charge of making medical decisions. It's typically a spouse or a child. And then appoint a backup by name and address. Then you need to sign the form. You sign it in the presence of two witnesses. Now, the witnesses should not be your agent or your alternate, all right? But once you've done that, you get your neighbors to come in and watch you sign, and they sign and put their name and address on. Now you have a valid Massachusetts healthcare proxy. Somebody can make medical decisions for you if you're unable to do it for yourself. Other states prefer a document called a living will. A living will does not appoint an agent. Instead, it is a set of written instructions from you saying, I do or I do not want certain types of care. All right? Generally, these are designed to be comfort care documents. Don't use extraordinary measures if I'm in a terminal unconscious condition. Again, if you can tell the doctor what care you want, the living will doesn't matter. But if you can't tell the doctor what care you want, then the living will is written instruction from you. Now, living wills are not recognized in Massachusetts. We only recognize the healthcare proxy. All right? Other states are just the opposite. They recognize only the living will and not the healthcare proxy. A few states, like Rhode Island, recognizes both by statute. So it's really important in my mind that you have both documents if you're going to have a good estate plan, so that no matter where you are, you've got the document preferred in any particular jurisdiction. It's also important in my mind that your healthcare proxy and your living will set a pecking order to say which one will control. So for example, if your healthcare agent says, oh, gee, the person's in a coma, they have COVID, they need to be intubated. If we intubate them, they'll recover. But their living will says, don't use extraordinary measures like breathing assistance, and intubation. And so you've got this conflict. The healthcare proxy may want to make a decision that is in conflict with the living will. Give that person the authority to do so, because you don't know what the facts and circumstances of the particular situation might be. You want to make sure that your healthcare agent knows your thoughts and your wishes, that they're not artificially extending your life, for example. If you don't want that, you want to talk to them and say, in this example I'd like this, in that example I'd like this, here's my thoughts and processes, and you want to get that warm fuzzy feeling that they're going to do what you want them to do, not whatever they might want to do. So for example, if you said, take some reasonable measures, try to keep me alive, you don't want somebody to be your healthcare agent who's going to say, I don't care, we're just going to pull the plug, right? So you want to make sure that you got the right person to make that decision for you. All right, the last document in incapacity care planning is a MOLST, Massachusetts Order for Life-Sustaining Treatment. Now, many states have something similar to this. It's a statute that basically says you and your doctor can sit down and go over what your maybe end-of-life care might be. If you've got that terminal diagnosis and you want to sit down and say, I don't want this, I do want that, you have the conversation with the doctor, and together you put together a document called a MOLST. It's kind of like a healthcare proxy, a living will, and a DNR, a do not resuscitate order, all combined into one. And once you've outlined what care you do want, what care you don't want, you sign it, the doctor signs it, and then it becomes an order in your medical record. And if you're in a hospital, a rehab facility, a nursing home, or any other kind of medical environment, that order is going to take control over what care you do or do not receive. Yes?
Have you ever heard of that conflicting with a clause in a life insurance policy?
No, but again, it's different. This is not like a physician-assisted suicide thing that would cause a life insurance policy to say, no, we're not going to pay. This is something that would say, what kind of care do you want? Do you want extraordinary means, or do you want comfort care?
And life insurance companies have nothing to say about that?
Not in my experience.
Okay.
All right. It's if you're in that situation, it is most likely that death is certain. It's just a question of, do we artificially extend your life, keep you on breathing tubes and respirators and that kind of thing, when maybe you're not there anymore? I can't say, but it's not a situation where a life insurance policy is going to deny a claim because you said, just make me comfortable. Okay? All right. Then we have decision-making and incapacity care for financial affairs. There's a court proceeding again, a conservatorship. Now, I kiddingly call this World War III. Imagine you're in a blended family, all right? You've got children from a prior marriage and a spouse that you have right now, and you don't have any documents that say who should be in charge if you can't be in charge yourself. If you're incapacitated, who's going to get to manage your money? Well, if you don't have any documents, a court's going to get to decide. And of course, everybody's going to want to be in charge of your money. The kids from the prior marriage, the spouse from the current marriage, and they're going to have conflict over who should be in charge. So, it's a problem if you have it, and it's very expensive. Any of these court proceedings, lawyers are going to be involved. If there's opposition, somebody doesn't agree, then you've got essentially a litigation situation involved, and it can be very expensive to get through that process just to figure out who's going to be in charge. So again, the better path is to do a little bit of advanced planning so that you say who should be in charge. If you have something called a durable power of attorney, you appoint an agent to manage your financial affairs for assets that you own in your name alone. your bank account, your stock account, retirement plan. Your power of attorney will have control over those if they're left in your name. All right? And your power of attorney is generally going to be the person who would be the conservator if one were required. And so that, again, puts the court on notice as to who you want to have in charge. All right? So it's an important document to have. Now, powers of attorney only handle the assets that are not owned by a revocable trust. So if you're using a trust-based estate plan, you can put assets into that trust while you're alive, and you have a successor trustee built into the document. Remember that we had our contract with three parties, a donor, a trustee, and a beneficiary, and you're going to be all three. But if you become incapacitated, you can't be the trustee anymore. So what do? Well, we make it so that you nominate somebody to take over if you can't be the trustee yourself. That successor trustee would step up and manage the trust to take care of things for the beneficiary. And simply because you're incapacitated, well, that doesn't end the fact that you're still the beneficiary. So now you're the person for whom the trustee is managing the money. You just can't do it yourself, but they're going to use your trust to take care of you. So the trustee manages the assets that are owned by the trust. The power of attorney manages the assets that are not owned by the trust. All right? So they work very well together, and you really should have both. All right, the next goal that we have is probate avoidance. And in order to understand why we want to avoid probate, I need to go in to explain a little bit about what is probate. It is a court proceeding that occurs when you pass away, and it works on conveying assets you own in your name alone to your heirs. So for example, if I own a piece of real estate in my name alone, it has to go through probate when I die. If I own a piece of property jointly, well, then it passes by operation of law to my co-owner. So we don't go through probate then. If I own an asset in my trust, well, I don't own it individually. It does not need to go through probate. So we like to put things into our trust as a way of avoiding probate. Now, probate as a court proceeding, it's based upon a will. It dates back to the statute of wills back in the 1500s. And this process basically says you take the will to the court, you get it approved by the court. Once it's approved, you appoint somebody to be in charge. We used to use the term executor. Now we call that person a personal representative. They changed the Latin term a few years ago. So we have that person who is in charge of managing whatever you own in your name alone, and they're charged with following the instructions you have in your will. If your will says give it all to my spouse, that's the responsibility of the personal representative to make sure that happens. If it says give it all to my trust, well, then that's what the personal representative must do instead. Now, the process lasts a minimum of 1 year. And the reason for that is state law says we have to give your creditors an opportunity to say, wait a minute, don't pay the heirs the inheritance yet. The deceased person owed me some money. I have a priority to get paid before the heirs inherit. Pay me first. So we give the creditors 1 year to make a claim. And if they don't make their claim on time, then they may not get paid. But we got to give them that 1 year. What that means is your spouse or your kids won't get an inheritance. The assets stay in probate until that 1 year time frame is over. All right? Now we then have the cost of probate. It's a court proceeding. Usually lawyers are going to be involved. And because of that expense, we can say as a rule of thumb, it's going to run around 5% of the asset values that are going through that probate proceeding. So if you've got an estate worth $1 million and it's all going through probate, you can expect to spend about $50,000 in attorney's fees, accountant's costs, appraisal fees, filing fees, and a series of other expenses that are all required to go through that probate court process. The one thing that's not on this slide that you should also be aware of is privacy. You know, wills and the estate process, the probate proceeding, are public records. I don't know about you, but I remember several years ago when Jacqueline Onassis passed away. I remember going to the Stop and Shop and going through the checkout line, and there was one of those newspapers, I'll call it that, the Inquirer or the Star, and on the headline was, Jackie O's estate worth so many million. And I kind of scratched my head and I said, I wonder how they found that out. And then I thought about it. The reporter just went down to the probate court in New York, which is called the Surrogates Court, and said, I'd like to see the file for Jacqueline Onassis, please. And you'd think, well, you can't have that. That's private, right? No, it's public record. Clerk went into the vault, found the file, came out, dropped it down on the counter. The reporter just leafed through it, and old school was you file something called an inventory. It's a report of everything that the person owned at their death, including the values of everything. So she just found the inventory and took notes and then wrote up the article saying, well, her probate estate's worth X many dollars, right there in the inventory. So it's public record. Most people don't want that. We want to avoid the cost, we want to avoid the delay, we want to avoid the public nature. And in order to do that, we use other techniques to avoid owning things in our name alone. If you own it in your name alone, it has to go through probate. I was giving a seminar about 10 years ago, and a woman in the back of the room raised her hand and said, yeah, I have a will. I name my daughter as the executor, the person going to be in charge, and she's just not going to go to probate. She's going to take my will, and she's going to go to the bank, and she's going to go to the brokerage house, and she's going to just say, here's the will, I'm in charge, let me do what I need to do with the assets. And I had to unfortunately tell the woman that, you know what, your daughter's going to find very quickly that those institutions will not even talk to her until she gets an appointment paper from the court saying, yes, it is the will, it's the final will, it's the only will, and yes, she in fact is appointed to be the person in charge. It's just not going to work that way. She's not going to get anything until she does go through probate. So better to avoid probate altogether. Don't own assets in your name alone. I don't think joint property is a great tool, but I think owning things that have beneficiary designations or using a revocable trust is the most effective method of getting assets passed without having to deal with the delay and the expense of probate. All right. The next goal we want to talk about is asset protection. We're going to break this into two areas again. Asset protection for you as a client, and then asset protection for your heirs. Why are we concerned about asset protection for you? Well, you've spent a lifetime trying to develop the wealth that you've achieved, and you want to keep it so that it's there for you. We find that litigation is one of the biggest risks that people face. 94% of all of the lawsuits filed in the entire world are filed here in the United States. In Massachusetts, the last time I checked, 1 person in 5 was likely to be sued in any given year. 20% of our population could get sued. That's a pretty high statistic. And so what we want to do is structure things so that we're not going to have that risk.
Anything to do with the number of lawyers we have in this?
Of course it does, yes. We're cranking out lawyers all the time. And how do most lawyers make their money? They sue people, right? I'm not one of those people, so I'm one of the good guys, right? I'm trying to make it so that you keep your money, all right? So, it's a good question. Why is it that we have these problems? Yeah, well, we're cranking out lots of lawyers, and lawyers have found that the way to make a living is to file litigation. Now, litigation is really expensive. The cost of litigation for the most common kind of litigation, an automobile accident, runs around $35,000 to go from beginning to end. If you have a property dispute with your neighbor, you build a fence and the neighbor says, you put it on my side of the property. You say, no, I didn't. And they sue you. Well, you're going to spend about $60,000 to go from the beginning of the lawsuit to the end just to defend. If you're in the right, you still have to defend that lawsuit. Doctors face medical malpractice suits. They leave the sponge, or it's claimed they left the sponge in the abdomen. Well, you know what? You're going to litigate that. That's going to run around $120,000 to go from beginning to end to defend that lawsuit. And if litigation is that expensive, you think, well, who can afford to start it? The plaintiffs face those costs too, don't they? Well, not necessarily. The plaintiffs' bars worked out something called a contingency fee. Tell you what, I heard you slipped and fell. You don't have to pay me a dime. You let me represent you. I will litigate this for the next 2 to 5 years. And when we get a settlement, instead of paying me hourly, you'll agree to pay me 30 to 50%, and they'll work out what that number is exactly. You'll pay me that percentage of the total recovery when we get our settlement. What does that do? It makes the lawyer gets a little bit of a windfall because they're taking on the risk, but you don't have to pay anything out of pocket to go through the litigation. So you've got no skin in the game. You've got nothing to lose by litigating. So what we want to do is structure your affairs because you, as a wealthier person, are perceived to have a deep pocket. So we want to structure your affairs to make it look like you're not a wealthy person. Because you know the plaintiff's attorney is going to do a background check on the defendant before they file litigation. They're not going to spend 2 to 5 years and then not be able to get anything at the back end. They want to get paid someday. So if we make it look like you don't own a lot, because we use irrevocable trusts and LLCs and other things that are very hard to pierce through and get assets out of, we are creating a disincentive for that plaintiff's attorney to file a lawsuit against you. So asset protection is important for you so that you don't walk around with that target on your back of, hey, I'm a litigation target, come and sue me. We want to make it so that somebody has no reason to come and sue you, but you still have the use and enjoyment of the wealth that you've created. Next, we want to talk about asset protection for your heirs. You know, you created wealth. When you pass your wealth, you're also passing the target that you may have on your back as a litigation target. So we want to make it so that your heirs don't inherit the target. The trick to doing that is simply making sure you're using the right preposition in your estate plan. Most people make the mistake of leaving everything to their loved ones. Instead, I urge you to leave things for your loved ones. That one preposition, to versus for, makes a huge difference in whether or not somebody can reach in and take the inheritance away from your child or your loved one, whoever it might be. All right? So don't use outright distribution. Most trusts, while they will avoid probate, are written to act like a will. When I die, I give everything to my kids. And if you do that, now they inherit not just the inheritance, not just the assets, but they also inherit the litigation risk. And so by leaving things for your kids instead makes much more sense. We'll talk about some specific techniques you can use to accomplish that a little later. Next, tax avoidance is our last objective we want to talk about. And again, we're going to break this into 2 components: income tax avoidance and estate tax avoidance. You know, the estate tax at the federal level has gone up over the years. Right now, it's you don't have an estate tax unless your estate is over $12 million if you're single, or over $24 million if you're married. So that for many couples many families makes estate taxes at the federal level irrelevant. And as a consequence of that, estate planners have stepped back and said, well, is that the only tax we should be worried about? Maybe it makes our planning a lot easier, but are there other issues? And there's a pretty big income tax issue that's involved in estate planning that, because the estate tax was so aggressive for so long, we overlooked it. It wasn't important because the estate tax cost was so much higher. There was some income tax burden that made it worthwhile to avoid the estate tax cost. Now we're looking at it a little bit differently, saying, well, maybe we need to be a little more tax sensitive on the income tax side of the equation. In order to understand what I'm talking about, let's look at how your will is going to be taxed when you pass away. If you use a will-based plan, the ordinary tax rate for a probate estate is 37% when the adjusted gross income exceeds a little over $13,400. Your capital gains rate is not 15% as it is for most of us, it's 20% when the income exceeds $13,700. Now, for these for these first 2 tax rates that we have, the 37% and the 20%, on the individual side of the tax rates, you know, if you're filing for yourself, you don't hit that 37% bracket, you don't hit that 20% bracket until your income is over somewhere more than $600,000 if you're married, something more than $500,000 if you're single. So a will is paying these much higher rates at a much lower level, only $13,000 some dollars. And every dollar over that, up to the $500,000 or $600,000, is still being taxed at the high rate. So we're paying more in taxes because we're using a will than we would be if we used other planning techniques. All right? So we also have something called a surtax. It's also referred to as the net investment tax. I'm sorry, I said that wrong. The net investment income tax, NIIT. It's a part of the Affordable Care Act. It's a 3.8% tax on income when your income exceeds a certain threshold. For you, filing your personal return, you're not subject to the surtax until your income exceeds $200,000 if you're single or $250,000 if you're married. Then you pay 3.8% on anything over that threshold amount. But for a will, we pay that extra 3.8% when our income exceeds that $13,451 number.
I'm confused. The will pays income tax?
Yep. So while you're probating, how does it work? All right, so I have an estate of $1 million and it goes through a probate. The $1 million is not income, but the interest and dividends that the $1 million generates while it's going through probate for 2 tax years is income. So to the estate, to the estate, to the probate estate.
Does the will have a tax ID?
Yes. Once you die, your probate estate, not the will itself, but the probate estate becomes a taxpayer and has to get a new tax identification number. And any income earned while we're probating your estate must go through a tax filing every year and pay these much higher rates. So we want to avoid this if we can.
So we want to keep all of our assets out of probate.
Ideally, yeah. Now, we can't just stop there, unfortunately. Now, the easy way to avoid probate is to put those assets into a trust, right? To put the house, the brokerage account, the savings account, all into a trust so that we don't go through probate. Unfortunately, trusts, if they're not drafted the right way, are subject to this same tax regimen. So how do we avoid it? We add language to our trust that says the income of the trust doesn't belong to the trust. It belongs to the beneficiary, even if they don't take it. This is something that's written right into our tax code that says you can do this. Section 678. So what we do is we say, all right, we're going to make our trust so that the income doesn't belong to the trust. It always belongs to the beneficiary. And the beneficiary will pay at whatever tax bracket they're in, which is almost always going to be less than this. And even if they're in the highest tax bracket, they're married and their income's over $600,000, you're saving the tax on the all the way up between 13-something and 600,000-something. So we're paying less in taxes because we use this kind of a structure. But it's something that has to be added to your trust, and your estate planner has to know to add it to a trust. If you have a trust already, you may need to modify it to make sure that it avoids this problem when the trust becomes irrevocable. Now, let me just go back for a second. I said trusts have this problem too. Like a will, they don't start out as a separate taxpayer until you die. And when you die, they become a separate taxpayer. We have to get a new tax identification number, and the trust will need to start filing its own tax return, a Form 1041, every year to report whatever income it received. But if it's built the right way, it can just file a report that says, here's all the income we received, here's all the deductions we would have been able to take if we were a separate taxpayer, but instead we're just passing that on to the beneficiary. They'll put it all in their personal 1040, and the trust doesn't pay the tax. So your trust has to be built the right way so that when it does become irrevocable, it's not going to pay these higher taxes.
So in that case, it doesn't need to have a tax ID?
It does still get a tax ID.
It still does.
Yeah. Well, let me I shouldn't say it so definitively. There's a ruling from the IRS that an irrevocable trust that's built the right way can choose either to have its own tax identification number or to use the Social Security number of the beneficiary.
What if it's multiple beneficiaries?
You break it up into separate shares, and each one would use their own Social Security number. I don't think it's a good idea to use a Social Security number because then you don't file a trust return and you just put the income on your personal return. Now if you have a creditor problem and somebody's saying, well, you're not honoring the separateness of the trust, and you're putting all the income on your personal return, it looks like you're not honoring the separateness of your trust. So I think you're better to file the separate tax return for the trust to show, yes, it still files it just under a tax rule.
Because of that appearance, it makes the trust easier to pierce?
That's the concern.
Okay.
That's the concern. Now, it all depends on the particular judge you get. If the judge understands that the income tax code allows you to pick which method, they may say, sorry, that in and of itself does not allow us to pierce the trust. But I don't want to take the risk. file a separate return.
Just the appearance of,
Right.
this is just a pass-through.
Right. So file a separate return and report that income on that trust return, but then say it belongs to the beneficiary even if it stays in the trust. And that's the way to avoid that problem, all right? But this requires some specialized language be added to a revocable trust to exercise the requirements of Section 678 of the Internal Revenue Code to say your trust honors certain provisions. It has certain provisions built into it to say the beneficiary has the right to take the income out, the beneficiary has the right to swap assets with the trust, or a few other things that are in that 670 series of the tax code that allows us to get this tax treatment that's far more favorable and will save your family tens of thousands of dollars over the lifetime of your trust. Okay? All right. That's the income tax issue. Not just one of the income tax issues. There's another one I'll talk about a little bit later. But right now I want to turn to estate tax avoidance. In order to understand how we can avoid estate taxes, we have to understand a little bit about the estate tax code. And basically what we do when somebody dies, there's a one-time return that needs to be filed, a Form 709, or in Massachusetts, an M7, I'm sorry, I used the wrong term, M706 or a 706. It's a tax return that basically says, here's the estate of the person, here's everything they owned, and here's a few deductions that we're taking, and if they exceed a certain amount, then we have to pay a tax. So let's look at that in greater detail. We look at all the different asset categories somebody could own: real estate, investments, bank accounts, life insurance, jointly held property, miscellaneous property, automobiles, trust-owned assets. So simply because you get a revocable trust doesn't take it out of your taxable estate. A revocable trust is still a part of your estate, all right? Then you can have something called a power of appointment. You know, if your parents created a trust and said, you have the right to the income for the rest of your lifetime, and at your death, you can decide who's going to inherit the assets in my trust. You have to do this in your will. Here's how you do it. That's a power of appointment. You can exercise the power over your parents' trust to say who gets the assets. That power of appointment, in many circumstances, will cause their trust to be a part of your estate. Then finally, you got annuities and other retirement accounts. So you add all of these up, and that's called your gross estate. And I don't mean gross as icky, I mean gross as total, all right? Now we're going to take a few deductions. Funeral expenses, unpaid bills, you know, utility bill, credit card bill, mortgage, fiduciary fees, and charitable gifts. We can deduct those. Now, those first four deductions for most families, when you compare it to the total size of the estate over here, it doesn't help out a whole heck of a lot. All right? Those deductions can add up to, you know, a $10,000 plus bill, but it's not going to give us enough to really save on estate taxes. It's the last two of these deductions that most people use, and unfortunately, most people make the mistake of only using the first of the last two, assets left to a spouse. They overuse that and they give up the estate tax exemption. If it's a married couple, they give it up at the first death, and that can cost them about $100,000 in taxes. Yes?
What would be the fiduciary? Would it be the executor of the trust?
Yeah, the person in charge of the trust is the executor. If you have a will and there's a probate, the person in charge is the I'm sorry, I think I may have said that backwards. My apologies. The person in charge of the trust is called a trustee. The person in charge of your probate estate is now called the personal representative. The IRS still uses the old term executor. What we do is we'll look at if you've got both of those fees are deductible. Okay, if there's any other fiduciary fees involved and they're part of the taxable estate, we can deduct those fiduciary fees. All right?
If a trustee isn't a paid person, then obviously there's no fee.
Well, right. So most of the time we pick family members to be our fiduciaries. They are entitled under a will to take a reasonable fee and really under a trust to take a reasonable fee. Our trust dictates or suggests a fee schedule, but you know how you handle that with your family is up to you. Many times the children who act as a fiduciary will forego a fee, but they are entitled to one. And there's a lot of work that's involved in settling somebody's affairs. So it's something that it's appropriate for them to charge something. All right? All right, so our exemption amount is $12,060,000 at the federal level, which, if you're married, you can double that. And at the state level, it's $1 million. Now, there is a proposal to raise that to $2 million. I don't really see that as likely to pass or to move through this legislative session. A few years ago, we thought they were going to pass it, and it was really close, and something happened. COVID was part of it, but other things happened, and it all fell apart. So right now, we're looking at that $1 million at the state level exemption. The trick to me is using the Massachusetts $1 million exemption when the first spouse of a couple passes away, so that we can preserve that exemption. But most people instead just use the marital deduction by leaving everything to a spouse, and they're giving up the exemption of the first to die. I'll show you an example of that in just a second. Another concept we should talk about is portability. This is only available at the federal level for federal estate taxes. A couple of states have passed it. Maryland has passed state portability, and either Michigan or Minnesota, I've forgotten which, have also passed state portability, but we don't have it here in Massachusetts. Portability is the idea that says if I die with a $1 million estate and I have a $12 million exemption, I can leave the unused $11 million to my spouse, so that my spouse will have her exemption plus my unused exemption. And I often suggest that to a surviving spouse. But I'll often be met with the quizzical look of, Keats, I've got $12 million of my own exemption. Why do I need my deceased spouse's $11 million? And that's because Congress can change the exemption. You know, you've heard, what Congress giveth, they can taketh away. Well, they've changed the exemption on us in the past. Fortunately, in the last several years, it's moved its way up, but they can just as easily move it down. Last year, they were proposing to move it down to either $5 million or $3 million. Excuse me, $3.5 million. A few years back, they wanted to move it down to $1 million.
Sorry, can I just go back to
Yeah.
the grossing up the estate? How do you value the real estate?
You value real estate by getting a paid appraisal. You can't use a market analysis by a broker. You can't use the assessed value. You have to hire an appraiser and have them do their thing and tell you, okay, I think based on comparables that are available for the date of death, here's what I think the property was worth. All right? We do something similar for stocks. You technically have to get the average of the high and the low for the day that somebody passed away, and that average is deemed to be the date of death value under IRS rules. Banking assets, we have to look at what was in the account on date of death plus any accrued interest. So you go through this process of trying to identify everything to determine what the date of death value was. All right? All right, so portability, it's optional. You don't have to use it, but if you're going to use it, you have to file a federal estate tax return in order to move the assets over to a surviving spouse. The reason a surviving spouse may want to use portability is Congress can lower the exemption. Let's assume for a second you've got a $2 million estate. And if the first spouse dies, you leave everything by marital deduction. Now the surviving spouse owns the full $2 million, and we didn't do portability. And between the deaths, Congress lowers the exemption to $1 million with a 50% estate tax rate, something that could happen realistically. If that were to be the case, you'd have a $500,000 estate tax on the last $1 million of the $2 million estate. By using portability, moving that $11 million or $12 million over to the surviving spouse, the spouse would have their $1 million plus the unused amount of the first to die and can eliminate that estate tax entirely. And so that can save hundreds of thousands of dollars, and that's the reason why we recommend somebody choose to file a federal return, even though they may not be required to otherwise, so that they can elect portability. All right?
But we don't have it in Massachusetts anyway.
We don't have it at the state level, but it's a federal concept, and that's where we're concerned about the tax. If the feds lowered the exemption to $1 million, it could be a problem for a lot of families.
If the feds lowered the exemption, wouldn't the portability become gone too?
Only if they built that in the law. The assumption is that they wouldn't.
Okay.
All right? And could they? Yeah, they could. But, you know, I think right now it would be deemed to be somewhat unfair to require somebody to file a return to get portability and then take it away. So again, you know, it would probably end up being litigated, and how it would turn out, you know, Congress can pass just about whatever they want as long as it's within constitutional bounds. All right, let's look at a couple of examples. What I want to do here is I'm going back to that prepositional difference of leaving things to a spouse versus leaving things for a spouse. all right? We're going to obviously side on the favor of leaving things for a spouse because you get better protection from taxes by doing that. So let's look at a $3 million estate. And I'm using this number because I want to result in some tax after the death of the second spouse. So we can do that two ways: by passing that $3 million to our loved one, either by a will, but if we use a will, we're going to have probate, or by using joint property, and we'll avoid probate. Let's start with the will. What's going to happen? Well, we've got a $3 million estate. Our probate costs will be about 5% of that, or $150,000. Well, it'd be nice if we could save that $150,000, wouldn't it? So what we want to do is not go through probate. How do we eliminate the probate expense? Well, maybe we'll use joint property instead. All right? So now we're leaving everything by joint property to the surviving spouse. What's our estate tax situation? It would be the same tax if we had a will, by the way. So we've got a $3 million estate. We're leaving everything to our spouse. We can take a marital deduction. So we have no federal and no state estate tax because we're giving everything to the spouse, and we've got a marital deduction at 100%. All right? So no tax. Now the surviving spouse owns the full $3 million. What's going to happen when the surviving spouse passes? Well, here we don't have a choice to take it out of the spouse's name by using joint property. Well, I shouldn't say it that way. We could put it into joint property with maybe a child, but I've talked about the problems that you can run into. You know, divorcing spouse might take it away, a creditor of the child might take it away. We can run into other problems of the wrong kids getting the wrong percentages. So we just don't use joint property. That means we're going to have a probate when the surviving spouse dies. Cost of about $150,000. What's the estate tax consequence? Well, we've got a $3 million estate, but only we've got the $12 million federal exemption, so we're not going to have any federal estate tax. We've got a $3 million estate, but only a $1 million state exemption. So that leaves $2 million that would be subject to the tax. Now, if you want a quick rule of thumb how to calculate the Massachusetts estate tax, take the gross estate, subtract the $1 million exemption, whatever the difference is, multiply it by 10%. That will give you about $200,000 in this example. The actual tax is $182,000. So we're going to lose over $330,000 between probate and taxes. That means you're making your lawyer and Uncle Sam, or at least the Commonwealth of Massachusetts, an heir to your estate. You don't have to do that. We can cut out at least the lawyer and get a better result. So what I suggest is leaving things for your spouse. Put things into a revocable trust. Now, if you're married, we like a joint trust, one trust for the couple, rather than a separate trust for the husband and a separate trust for the wife. There are some tax advantages I'll talk about shortly with that. But with that joint trust, what are we going to do? Well, because it's owned by a trust, when one spouse dies, everything avoids probate. You know, the trust doesn't go through the probate process because the trust hasn't died. The trust still goes on. We change the trustees, we change the beneficiaries, but the trust still exists. So now we have no probate expense at the first passing. We have a $3 million estate, and we have the option here of taking $1 million and moving it into what we refer to as the C trust. In Massachusetts, you probably heard of an AB trust. Many states don't have a state-level estate tax, and so they break the trust into an A portion, the amount for federal estate taxes you can pass estate tax-free, and a marital deduction trust for everything else. What we want to do here is break it into 3 trusts, one for the Massachusetts exemption, and we could use the middle trust, the B trust, for the balance of the federal exemption if we wanted to, and the A trust is our marital deduction trust. In this case, right now, we only recommend using the C trust, the credit shelter trust. Now, that credit shelter trust can be named a number of things if you have a trust. You can go and look, it might be a remainder share, an exemption trust, a bypass trust, a family trust. All of these types of names are synonymous with a trust that's intended to shelter a certain amount of money from estate taxes when the surviving spouse dies. Here in Massachusetts, we'd put up to but not more than $1 million into that C trust. That trust does not belong to the surviving spouse, but it is available for the needs of the surviving spouse. In other words, the surviving spouse can get income, interest, dividends, rents, or royalties. They can take principal out if they want it to maintain their standard of living or for their medical needs or for their own education. But that restriction of saying you can only take principal out for these limited reasons, first, it's a very broad restriction. Your maintenance and support, maintaining your standard of living for your own medical needs, that's a pretty broad restriction. If you can get at that, you're probably going to be good. And quite frankly, we don't want to touch that if we don't have to, because we still have more over on the other side. We've got another $2 million, and we know the surviving spouse only has a $1 million exemption. So if we have to spend down, better to spend out of the $2 million, not out of the $1 million we're trying to shelter. All right? So anyway, we break it off so the $1 million does not belong to the surviving spouse, but is available for the needs of the surviving spouse. Then we have the remaining $2 million staying in the revocable trust. What's the tax consequence at this stage? Well, remember, again, we're avoiding probate because it's a trust. We are now sheltering $1 million. We're using the exemption of the first to die to fund the credit shelter share, the C trust. Then we've got $2 million that will belong to the surviving spouse, and we're taking a marital deduction on that. So we have no estate tax at the first death. But now the second death occurs. What does the surviving spouse own? Well, again, it's in a trust, so there's no probate. So we're saving $150,000. Now the only thing the surviving spouse owns is the $2 million on this side of the screen. We have a $1 million exemption, but we only own $2 million worth of assets, but it still leaves $1 million subject to tax. Remember that 10% rule? 10% of that difference would be about $100,000. The actual number is $99,600. So we save the probate expenses at both deaths, and we cut the estate tax down because we use the shelter of the first to die. We use the exemption of the first to die. We preserve that $1 million exemption. So now we're effectively passing our estate using $2 million worth of state-level exemption. Does everybody follow me? I know I've thrown a lot at you.
The $100,000 that's in the C trust,
Yes.
on the death of the second spouse.
Who gets it?
Yeah, where's that?
Okay, so the C trust on the far side of the screen, that will then go to the heirs. So what happens is the trust, not for estate tax purposes. It doesn't belong to the surviving spouse. Effectively, it belongs to the first to die. And they have a $1 million exemption, and we've kept that exemption alive.
Even though they're already dead.
Even though they're already dead. We've preserved it, and we've kept it going for the surviving spouse's lifetime, so it doesn't belong to the surviving spouse.
It's like an asset that hasn't gone out of their estate yet.
Effectively, yes. It's an asset that hasn't gone out of their estate. That's a good way.
confusing.
It is. It is very confusing. But by doing that, you're saving $100,000 or more of estate tax. All right? So it's a good technique to consider. Now, is the technique right for everybody? I'm going to confuse you a little more now, probably. Yeah.
Well, isn't one of the biggest problems, this is simple, if it's all cash. If we're talking about illiquid assets and, you know, there are big taxes to pay, and somebody owns a house worth $2 million.
Right. What do you do?
House.
No, you don't. That's the beauty of this. So, you know, we can fund with cash or in kind. So, for example, let's say the only asset that the couple owned is a $3 million home. We can divide the value of the home into 1/3 going into the credit shelter trust and 2/3 staying in the revocable trust. If it's stocks, we can put certain stocks or bonds into the credit shelter and move other over into the, keep it in the joint trust. We can divide the assets percentage-wise if we need to. So there are techniques we can use to allocate the funds, even if they're illiquid, into these different shares.
There are 99,000.
Well, yeah, that's true. And so, yeah, there may be a need to come up with some cash. But here, you know, if you've got an estate that ends up with $100,000 of estate tax, first, we've saved it somehow from more in tax and more in probate. But we do have to come up with some method of paying the tax. The trust gives you flexibility as to how you come up with it. You don't have to sell. If you've got a brokerage account, you can open up a margin and borrow against the stock. You could go out and get a loan from a bank. A trustee is authorized to borrow against the assets. If the bank won't give you the loan and a family member is willing to, you can borrow from a family member at reasonable interest rates. There's lots of possibilities here to come up with that liquidity to pay the tax. All right? So the fact that the estate is illiquid doesn't change the strategy to reduce the tax. All right? But we just may have to come up with some creative ways to find the cash to pay the tax. If the estate is that illiquid, one of the things that most estate planning attorneys should at least approach you about is considering whether or not to use some form of life insurance as a way of coming up with the cash to pay the tax so that the estate doesn't have a liquidity problem at the time the tax is due. Estate taxes must be paid 9 months from date of death. So you die, we've got 9 months to figure out where we're going to come up with the money. If you do some advanced planning, we can reduce the amount of money that needs to come up by using a trust rather than a will, and maybe we can find a way of coming up with a liquidity if the estate is that illiquid.
If you only have 9 months and probate can take 2 years, what happens for that?
You still have to pay the tax at the 9 months. The probate estate has to come up with the cash.
The tax hasn't been determined yet.
No, the tax has been determined at 9 months. You can determine what tax is due. It's based on the date of death value of everything owned by the decedent. We may not have given it to the ultimate heirs yet. We may not have finished the probate process of changing title from the decedent to the heirs, but we should have known what everything was worth on the date of death.
So none of the probate process determines anything to do with the amount of the tax?
Right. They're different processes,
Okay,
all right?
okay.
The probate process is all about how do we change title from the decedent to the heirs. The estate tax process is what did the person own on the day they died, what was it worth, and do you have enough deductions to eliminate the tax? All right, and they both go on concurrently, but you have to pay the tax at 9 months.
Estate tax.
The estate tax, right.
Estate.
The estate tax, the death tax.
What about the Massachusetts tax?
That is an estate tax. There we got federal and state. They are both due 9 months after date of death. So whichever you may be subject, if your estate is over 12 million, you could have a federal estate tax as well. Not likely, but for most people it's not an issue. But you have to pay whatever tax is due at the 9 month point. All right? All right. So let me go back now. What I want to do is turn to one of the things we do here is with the joint trust. We've built this trust with a really special tax advantage that most firms don't bother to give you. And so this is, I think, a real advantage. By using one trust instead of two separate trusts, we have the ability to say that when the first spouse dies, everything in the trust, not just what the decedent spouse contributed, but everything in the trust belongs to the first to die. Now, in our tax code, there's a concept called step up in basis. This relates to capital gains taxes. So if, for example, if I bought a stock at $10 a share and over time it grows to $100 a share, I have a capital gains tax I face if I sold the stock at 100 a share. I have to pay the difference between what I tax on the difference. What I paid for the stock versus what I sell it for. That $90 of growth per share, I have to pay a capital gains tax on that. Now, the tax code also says that if I hold that asset until my death, and if I'm the only person that owns it, I get to change the basis from what I paid for it to its date of death value. So we eliminate the capital gain on that asset. All right? We build this joint trust so that when the first spouse dies, the first spouse owns everything. And by having the first spouse own everything, we get a step up in basis on everything in the trust. So now if we have a house that we bought for $50,000 and today it's worth $750,000, we could be facing a capital gains tax if the survivor wanted to sell it. Most planning would say you'd only get a 50% step up in basis. Or if it was in the survivor's trust, the house was owned by the survivor and the husband's trust didn't. Let's say the husband passed first and the house was not in the husband's trust, you get no step up in basis.
So everything in this joint trust goes to the person who's already dead?
At the beginning, yes. We say it's all owned by the person who dies.
Okay, and it's not subject, it doesn't get after the fact, subject to estate tax of the first person's death.
It does.
It does.
That's how we get the step up in basis. But because it's all going for the surviving spouse, we don't have a tax due at the first death. All right?
Okay.
So if we say, credit shelter trust and revocable trust, no tax due because we structure it this way. Even if we say everything goes to the revocable trust, we get a marital deduction, no tax due at the first death. So what's the problem in saying everything belongs to the first to die? There isn't one. There's no estate tax consequence. What we do get, though, is the ability to change the cost basis to the current fair market value, which allows the survivor to sell the brokerage account, to sell the real estate, to sell whatever, without a capital gains tax exposure. So this can save tens of thousands of dollars or more, depending on your particular portfolio. This is very unique to our trust. Most people don't do this. Most people, if they have a joint trust, you only get a 50% step up in basis, which helps, but it's not necessarily going to be huge. And if we have separate trusts, you may get 0 step up in basis on the assets that are owned by the surviving spouse's trust. The joint trust allows us to get the step up at the first death and gives us a path, if we want it, to get a 100% step up at the second death. For example, the surviving spouse is younger than the first to die and has longevity in his or her favor. So they might live another 10 or 20 years. Now, if we put the assets into the credit shelter trust, and over 20 years, those assets double and double again, which is, the rule of 72s. Your assets will tend to double every 10 years. They may not buy anymore, but they may double in value. We could have a very large tax shelter over there. But what we've done is we've saved the kids some estate tax, but we forced them to deal with a capital gains tax that could be larger than the estate tax they'd face if they kept everything. All right? So we give the surviving spouse the option to fund the credit shelter trust or to keep it all. If the surviving spouse says, I don't like Massachusetts, I'm moving to Florida, where there is no estate tax. And so you could avoid that estate tax by structuring things in such a way as to make it so the surviving spouse still owns everything and we don't need the tax shelter because the surviving spouse is going to move to Florida where there's no estate tax and we don't have to worry about the Massachusetts estate tax. We could move to New Hampshire where there's no estate tax. And we've got options open to us so that if we don't want the tax shelter, we maybe have other ways of avoiding the state level estate tax. All right, so the idea here is this trust is super flexible. If we want to avoid Massachusetts estate tax, we have a mechanism built into it where you can choose to do so. But we don't force you into that choice. We give it as an option so you can decide what makes sense. Planning for you today, I don't know which tax will be the bigger tax, the Massachusetts estate tax or a capital gains tax your kids could face when they sell the assets that we shelter. I just can't tell you which is bigger. But when the first spouse passes, time has gone by, maybe we'll have a better idea. If the surviving spouse is in their 90s, unfortunately, we're probably not going to have a lot of time for appreciation, and we're probably not going to move to Florida. So we can probably say that doing a tax shelter is a good idea. So we'll wait and see, and at the first death, we'll be in a better position with more information to make the right choice then than we have now. Separate trusts, you're being forced to plan for estate taxes, and that could be the wrong choice. Okay?
If I have a house in Massachusetts and I move to Florida or New Hampshire to avoid estate tax, but I've kept that house.
You're still subject to the Massachusetts estate tax. I'll talk about that
On
in a little
that
bit.
house.
Yes. All right. All right, let's talk about some building blocks. And I'm not going to spend a lot of time going through all of these because I'm already running a little long. Typical lawyer, I take as long as you'll let me. We have the contract to plan. This is a contract, an agreement between spouses to say, I give everything to you, you give everything to me, and we both agree to leave it to our kids to protect against accidental disinheritance. And this is allowed by the probate code that was passed around 2005 or so. And it's, again, a contract contract with spouses, protects against remarriage, undue influence, charitable giving, or inappropriate favoring of one child over the other. So it's something that you should have if you're married. The healthcare proxy and the living will, these are tools that are required for medical decision making. We've talked about them already. It's something really simple to include, and every plan should have both documents, in my opinion. And power of attorney is next. Power of attorney is a document that manages assets if you become incapacitated, is how we think of it. Now, we have two types, immediate versus springing. A springing is a true incapacity care document, but you can give your agent the authority to manage your financial affairs right away if you want to do that. For clients who are in their 80s, it's often a good idea to give an immediate power of attorney so we don't have a delay of taking the person to the doctor, having them examined, getting the doctor to write a letter, then giving the power of attorney that letter that they can then take to the bank or to the financial institution so that they can start managing the person's affairs. Sometimes an immediate power of attorney is a little easier to work with, but that power of attorney is an important thing, especially if you have retirement accounts. You should not put a retirement account into a trust. The IRS says if you change ownership of a retirement account, you're withdrawing all the money from that retirement plan. And when you withdraw money from a retirement plan, you have an income tax due on the value of the amount of the amount pulled out of the plan. So we don't want you to take that money out. We instead want you to just work with it and let your power of attorney be in charge. Don't put your IRA into your trust. Let your power of attorney manage it. But that means when you have a power of attorney, it must address certain retirement account features that are unique. The ability to change custodians. You know, most powers of attorney will say the agent has the power to manage stocks, bonds, mutual funds, etc. All right, so they can buy and sell within your IRA. But if you're at one company as a custodian and the agent thinks, you know, they're overcharging, they're not doing a good job, we want to move it to somebody else, do they have the power to do that? If your power of attorney doesn't say so, they might not. So you got to make sure your power of attorney addresses things that are unique to retirement accounts, because IRAs, 401ks, 403bs, and other qualified accounts are probably the most important asset your power of attorney will be managing. All right, so you really got to make sure that that's addressed in that POA. Then you've got a will. A will is not going to be the most important document in your plan. It's really a safety net. There to catch things you may have forgotten to put into your trust, or things you've intentionally left outside your trust. Things like a day-to-day bank account maybe, or your automobile. Hopefully not much more than that. Now, if you do have a will and there's something to go through the will through a probate, there are basically two types of probate. Technically, there's three. There's a formal, an informal. Those are the type we want to avoid that cost so much and take so long. But the third type, there is something called a voluntary. It's a simplified probate proceeding that's available for estates that don't have a lot to go through probate. In Massachusetts, you can use a voluntary if you have less than $25,000 worth of stuff plus one car. Now, it could be a Bentley. But if the other stuff is valued at less than $25,000, we can use that simplified version of probate. It has a filing fee of about $120 and roughly is done in about 90 days. Most of our clients, if they have a probate, that's the kind of probate that they have, and that's the one we want them to have if they have to have one at all. Okay? Next, we have our revocable trust. Now, this is a trust that you can amend or cancel at any time. You put something into it, you can always take it back. So we want to have that revocable trust. That is the centerpiece or the cornerstone of the modern estate plan. Trust can have outright distribution, just like a will, where you say, when I die, it goes, it may be held in trust for your spouse during your life, during the spouse's lifetime, but then when the spouse dies, here you go, kids, it's yours, good luck with it, the trust is going to end and go away. You now own all the assets. The problem with that is good people can have bad things happen to them. There's a case out of California a few years back where a gentleman hit the gas pedal instead of the brake right in front of the Santa Monica farmers market. And he drove through the farmers market, injuring scores of people, doing a lot of property damage. The total bill in 1984, I believe it was, came to be about $12 million. You can only imagine what that would be today. All right? It's a lot of money. Now, you don't want your kids to lose their inheritance because they hit the gas pedal instead of the brake. And so what I suggest is not to use outright distribution. Instead, remember that prepositional difference. Don't give it to your kids, leave it in trust for your kids so that they can be in control, they can use and enjoy, but technically they don't own what they're inheriting from you. So we use a trust that uses a series of provisions that we have an acronym for. It's called the PAT, Personal Asset Trust. Each child will become the trustee of his or her own share of what they're inheriting. They can decide how to manage their share of the trust, and they don't have to work with any of their siblings. They can if they want to, but they're not required to. If they want to keep the family home in the Cape, okay, 3 kids, a third in each share. And they can, as a team, work together to pay the bills, pay the maintenance, keep the property taxes up, keep the homeowner's insurance up, and use it by taking turns every summer. And they'll work out the details for that if that's what they want to do. If one wants out, the other 2 can buy out that person, and that will be fine too. So we can use that personal asset trust as a way of trying to provide protection. And what we want to do is make sure that the child doesn't lose it if they get a divorce after they inherit, or if they have a lawsuit levied against them after they inherit, or they may need to file a bankruptcy, or they've got that target we talked about earlier where somebody's going to sue them for $1 million because they claim they spilt a cup of coffee on them. Whether the suit is legitimate or not, they have to defend it. We want to make it look like they don't own what they have inherited from you. Finally, we've got a second estate tax. And I think a really good asset to talk about for that is your Cape Cod home. Very often the kids love the home, they want to keep it going generation after generation. So it passes from you to the kids and the kids to the grandkids. What's going to happen from an estate tax point of view with a traditional estate plan of a will or a trust that leaves things to the kids? Well, that house is going to be subject to the estate tax when you die. Then it's going to pass to your kids. And when each one of them dies, that house is subject to the estate tax yet again. Then it's going to pass to the grandkids. And when each one of the grandkids die, it is again subject to the estate tax at each and every grandchild's passing. So how many times should that one asset be subject to an estate tax? From my perspective, it should be once. And a personal asset trust allows you to pass it to as much as 3 generations without having the estate tax hit it again and again and again. Because the heirs don't own what they inherit from you. We build it so that they can control what they're inheriting. They can decide what to invest in. They can decide to withdraw money out of the PAT if they want to do that. There are some limitations. They're only supposed to take it out for that same standard we have for the spouse: health, education, maintenance, and support. That's a very broad standard. But when you think about it, what will most kids want to do with their inheritance? Okay, yeah, they might take a vacation. They might want to buy a car. Well, those can be within their HEM standard. They can take it out, health, education, maintenance, and support. They can take it out and do those things. But the rest of the money, normally they're going to invest it. They don't need to take it out of your trust to invest it. They just need to shift the paradigm a little bit. They need to think that, hey, wait a second, this trust can own the investment for me. So if they say, gee, I always thought about having a condo in Florida. I'm not ready to retire yet, but when the time comes, the taxes are good, the weather's warm, okay, let's go buy a condo in Florida and we'll rent it out in the meantime. It's an investment property. Do they have to take the money out to go buy the investment? No, they can let your personal asset trust continue to own the property for them. The personal asset trust can rent it out. The personal asset trust can decide to give them the rent. The personal asset trust can keep the rent. And who's in charge of the personal asset trust? That child. So who's making the decision? The heir, the person who's going to enjoy and use whatever you're leaving them. If they want to invest in stocks, bonds, mutual funds, they have the trust do it. They don't take the money out to make the investment, they leave it in the trust. They want to have a business they want to start. They have the trust own the business for them. So they can get a lot of asset protection so that it's not subject to a divorce, it's not subject to a claim of a lawsuit, it's not subject to estate taxes when they pass away. It'll pass to the next generation free of estate taxes.
So they don't own it, they get to enjoy it though.
They control it and they enjoy it, yes. But they don't own it from a tax perspective, an estate tax perspective.
Or a legal perspective.
Right, from an asset protection and an estate tax protection, they don't own it. Now, we do build this so that from an income tax perspective, they own the income. While that may seem contradictory, the tax code lets us do this. And why do we want to let them own the income? because we don't want it to be paid at that 37% rate that we talked about earlier. We don't want it to be a 20% capital gains rate because the trusts have higher taxes. So we build it so the tax belongs to the beneficiary, the income belongs to the beneficiary. Yes, they have to pay the tax, but they'll pay less in tax because of the way we structured it, which means they get to keep more of the money.
So any asset within the trust that spits out income, you want that income to go to the individual.
We want the income to be taxed to the individual. Whether the individual takes it or leaves it in the trust will be their call. So if they don't need the income, they leave it in the trust, let it reinvest and make more money. And that will be available to pass down to the next generation. And by the way, if they have kids that are going through college, the trust is available to help to pay the college expenses of the grandchildren. And technically, it's maybe disclosable on the FAFSA, but in other words, you disclose that the trust exists. But because it's at the discretion of the trustee, they don't have to distribute a dime. It really is reported as a zero value because we don't know if the trustee will ever make a distribution to the grandchild. They can. In fact, they could even use it as a bank. You know, student loans can be very expensive from an interest rate standpoint. Your trust, after you die, can be the bank for a student loan at a more favorable rate. Right now, a long-term loan, you have to charge around 4%. That's going to be better than what the student loan rates are out in the open market. So you can use your trust as a way of providing a means of assisting future generations through this personal asset trust mechanism that you don't get with an outright distribution trust.
Does this take the place, is there still generation skipping?
This is a form of a generation skipping trust. It doesn't belong to the child, but it's available for the child and for the grandchildren. And because it's available for the grandchildren, it's a generation skipping trust, sometimes called a dynasty trust.
Tax returns due on those?
Yes. Same technique as earlier. Annual tax returns. It's considered to be what's called a grantor type trust. Again, you can use a Social Security number, but you're better to get a separate tax ID, file a separate return, say, here's all the income we earned, here's all the deductions we could take. We're not paying the tax IRS. We're giving all this information to the beneficiary, and they'll report it on their personal return. This only happens after you die. Your revocable trust that can have this personal asset trust built into it uses your Social Security number while you're alive. It is not a separate taxable entity. It's ignored from the IRS's perspective. All right? So that's how we structure this. So this is a great technique. This is for non-retirement assets that go into your revocable trust. IRAs, 401ks, 403bs don't go into a revocable trust, but maybe we want to give the same type of protection to your heirs. So we find that many people have as much or more in their IRAs as is the value of their home. You know, we think of our home as our single largest asset, but it's not necessarily the case. Very, very often, retirement accounts are more important or are significantly equal to those. And we've got this idea of leaving our IRAs to the kids. If you name a beneficiary, the child as the beneficiary, you're giving it to the child. If they inherit it and then they have a problem, a divorce, a bankruptcy, or a lawsuit, that problem can reach into the retirement account, and if it's a lawsuit or a bankruptcy, take the entire amount away from your child, leaving your child with the tax bill, right? If it's a spouse wanting a divorce, they can get something called a qualified domestic relations order and take half of the account out, and now it's their retirement, their inherited IRA. And you don't want that. You want it to stay with your child. So we want to structure something to protect against it. There was a case not too long ago at the U.S. Supreme Court, Clark versus Remacher. In this case, a woman had inherited an IRA from her mother, and she was doing what was allowed at the time, taking out as little as required. And so she'd take a little bit out every year, and the rest was just building up inside the IRA. Her plan was to use it to supplement her retirement account when she died. It was going to be like part of her retirement plan. Unfortunately, she and her husband ran into some financial difficulties and ended up that they had to file for bankruptcy. So when they filed for bankruptcy, she reported and said, I'm opting to keep my IRA. It's my mother's IRA that I've inherited, but it's an IRA. It's my retirement account. I opt to keep it because I have the right under state law to keep my retirement account. The trustee in bankruptcy said, no, that's not a retirement account, that's an inheritance. you have to turn that over to the bankruptcy court so I can use it to pay your creditors. So they fought it out at the bankruptcy court level, they fought it out at the appeals court level, somebody appealed to the U.S. Supreme Court, and the Supreme Court did an analysis. Is it a retirement account or is it an inheritance? Who's going to get the money? They found that an inherited IRA is an inheritance. It is not a retirement plan that's protected under the law. Now, we've known for years that an inherited IRA is also subject to the claims of a divorcing spouse. This is not anything new. So the trick here is not to leave things to your family, but instead leave it in trust for your family. So you've got your retirement account that doesn't name a child, but instead names a trust as beneficiary. And the trust will name the child as beneficiary of the trust. So now if the child has a problem, their problem can't break through the trust to get up to the retirement account money. We build the trust so that it's a bucket, so that money comes out over a 10-year time frame now into the IRA. I'm sorry, I said that wrong. Out of the IRA into the trust, and the trust will hold it. And the child can take out what they need to maintain their standard of living, and the rest will stay in the trust for future needs. Again, if they have a problem, their problem can't get into the trust to touch the money that's already been distributed. So it protects while there's money still in the IRA, and when the IRA is all paid out, it protects the money that's left in the trust. All right? So this is something that we think is very important. It's the IRA Inheritance Trust. If you've got a retirement account that's over $150,000 or combined value of all your retirement accounts, it's probably a good idea. If you're leaving it to a lot of different beneficiaries, you know, we had someone who had 16 grandchildren, wanted to leave all the IRA money to the 16 grandchildren. It's probably overkill if each beneficiary is getting less than $50,000. So, you know, keep that in mind. But how you structure it, we want the right people to get it. We also want them to keep it. And this IRA Inheritance Trust can do that. Now, I just briefly want to talk about the Secure Act, just to refresh your memory. A couple of years ago, Congress passed a new law that said IRAs, 401ks, and other qualified retirement accounts, when they are inherited, no longer have the ability to stay in the retirement account for the lifetime of the beneficiary. It used to be that when someone inherited an IRA, they could take a little bit out based on their life expectancy. They had to take minimum distributions. And this would allow the IRA to continue to grow for many, many years, maybe 30 years or more, and would get double, triple, even more from that retirement account over that extended period of time. It could grow to be a substantial amount of wealth because it was tax deferred. Now we have a general rule of the heir must take everything out in 10 years. They can take it all out in year 1, they can take it all out in year 10, or they can take it out in some installments in between. The IRS just issued some guidance that indicates you still have a minimum distribution. If you want to wait till year 10, you still have to take something out in every year, but then you take the balance out in year 10.
And
All right?
it's taxable as it's taken out.
If it's a traditional IRA, yes, it's taxable. So there are some exceptions to this 10-year rule. If you're leaving it to a surviving spouse, they can continue to use life expectancy. If you're leaving it to a disabled or chronically ill individual, they can use life expectancy. If you leave it to someone who is not more than 10 years younger than you, then they can use life expectancy. I like to use the example, if I left it to my brother instead of my kids, my brother's 5 years younger than I am, well then he could use life expectancy to pull that money out, all right? If you leave it to a child of yours who is a minor at the time they receive the inheritance, they can use life expectancy until they reach the age of majority, then they have the 10-year rule to work with. All right? So these are the exceptions. Not too many people fall into those. So basically, you've got a couple of choices with your retirement account. You can leave it to the individuals. Yes, they can take it out over the 10-year time frame, but they're not going to have asset protection. They could lose the retirement account. You could leave it to your revocable trust. The rules with revocable trusts are that you're generally going to have to take it out over a 5-year period. They're not built in accordance with all the regulations the IRS has issued to say if you name a trust, we can look through the trust to the beneficiary. Most of the time, a revocable trust doesn't meet that qualification, and most revocable trusts are built with the leave it to your beneficiary, not leave it for your beneficiary, so you're not going to get asset protection. So we like the third option of using the IRA Inheritance Trust. One, because the IRS reviewed this document in 2005 and issued a private letter ruling saying it meets all of our regulations. You're allowed to leave it in the IRA as long as our laws will let you. So if you want to leave it in for the 10-year time frame and comply with the rules, then the IRA trust complies with that, and it gives long-term asset protection because effectively it has the personal asset trust built right into it. All right? So it's a personal asset trust for retirement accounts that lets you take the 10 years so you get asset protection and as much stretch out as the beneficiary will be allowed. Next, we have our funding documents. So you can create a trust, and if you create that trust but don't put anything into it, you're not using your trust. If you're married, you're probably bypassing it because you own your home jointly. It's going to go to the surviving spouse and bypass your estate plan. So what you want to do is remember this contract, right? Remember this slide from earlier? We have our trust with our donor putting things into the trust that will be owned by the trustee for the benefit of the beneficiary. You have to take this step of changing ownership of your bank accounts, your stocks and bonds, your real estate holdings, so that your trust is the owner of these things. Once your trust is the owner, your trust is funded. So how do you do that? Well, it depends on the particular type of asset. Real estate, you have to convey a deed, sign a deed, record it at the registry of deeds, conveying the property from you to your trust. Your stocks, bonds, and mutual funds, usually you have to open up a new account in the name of the trust and have your old account moved into the new account. Banking assets, most of the time you can just go down, sit with your banker for a little while, say, here's a form my lawyer gave me called a certificate of trust. That's a summary that we give our clients. And they will take that summary of the trust and use it to retitle your existing banking accounts. Most of the time they won't change your account numbers. So it's really easy for savings, CDs, money market. They just change the name on the account. It's really simple. Few banks will say you have to open up a new account. And if that's the case, I don't want you to do it. So for example, checking accounts, I usually say leave in your joint names or individual name, but add a pay on death designation, naming your trust as the beneficiary when you die to avoid probate. So if your bank says we're going to change the account number and you got to reset up all your direct deposits and all your automatic bill pays, I don't want you to do that. I want to keep it simple. So we're going to just keep the checking account as it is owned now, but add that beneficiary designation, a pay on death designation, so that your trust becomes the owner automatically when you die. That way you avoid probate.
So a trust can be a beneficiary of another trust?
Yes, but that's not what I'm saying.
Oh, okay.
Okay? So for a checking account, it's in your names as a joint account now. I want you to add a beneficiary designation so that when the second of you dies, I want your trust to be the beneficiary. So that way it will pass to the trust by the agreement, by the beneficiary designation without the need of a probate. Okay? All right, so what else? We have business, ventures, LLCs. If you've got a business, you got to change your ownership interest from individually owned or jointly held to be owned by your trust. If you've lent money to a family member, you want to update your promissory note. Make sure you have a promissory note that shows your trust is the lender. Life insurance, non-qualified annuities, you generally want to update your beneficiary designation to name your trust as the beneficiary. And for retirement accounts, I like you to continue to name a spouse if you're married, but name an IRA inheritance trust as the beneficiary if you're not married or after your spouse dies, not the kids, so that they can get that benefit of asset protection. Now, if we've gone this far and you still have some planning needs, up to now, this has all been your basic kind of your starting point for a good estate plan. Sometimes we need to go a little bit further. If we want to do some asset protection, we might add a limited liability company. Now, what I want to suggest is that you avoid the legal Zooms of the world because you're not going to get the right kind of advice. If you go to a legal Zoom and say, I want to start an LLC, they're going to say, okay, you live in Massachusetts, let's organize you in Massachusetts. And I'm going to say, you know what? Massachusetts has one of the worst LLC statutes in the country. Not a good place to organize your LLC. To me, you want an LLC for asset protection reasons. And you want to look at two types of creditors. Inside creditors and outside creditors. What's an inside creditor? Okay, you got a two-family that you rent out. You can put that into your LLC. And if there's a slip and fall, they're going to sue the owner of the property. Well, if that's the LLC, yeah, they can sue the LLC. They might get the property that's owned by it, but they're not going to get your other stuff, your other rental properties, your bank account, maybe a lien on your home, maybe seize and sell the assets in a brokerage account that's not a retirement account. You don't want to run the risk of that. If you just own that two-family and there's a slip and fall, they can go after everything you own. If you put it into an LLC, they're barred from going beyond that LLC to get at your other stuff, the way it's structured. Now, I say that as long as you're not the person who caused their injury. So for example, if they went to grab the handrail and it fell off the wall and you're the one who repaired it the day before and you did it wrong, you're still going to be liable. They're going to be able to break through the LLC. But if you hire a contractor and you do your due diligence and they're insured and licensed and they just screwed up, you're not going to be subject to a claim, right? They may be subject to the claim, the contractor, but not you. So that will, that's why I want to say you're protected from inside creditors. What's an outside creditor? Unrelated to the business of your rental property, you're going out to meet some people for dinner. On your way home, you stop at the mini mart to get your half and half of the next morning's cup of coffee. And on your way out from the mini mart, you jump in your car and you put it into drive instead of reverse, and you drive through the mini mart and 5 people are inside. They all want to sue you for $1 million, claiming they can never go back to work. Can they break through your LLC to get at the rental property if they win their lawsuit? Depends on where you organize your LLC. Florida has a statute that says if you're the only owner of your LLC, it's a single member LLC, then yes, they can break through. Well, we don't want that. So we go to a state, there's several, we look for a state that says the only option of an outside creditor is to get something called a charging order. It's the right to wait around until the LLC ends and liquidates, and then they get to participate in the liquidation. Nobody's going to want to wait around 30, 40, or 50 years for your LLC to end. So it gives you the opportunity to settle with them to make them go away. So it also protects the asset so that there's still the income stream in there, and there are other ways for you to pull money out of that LLC by being an employee and taking a salary, by doing a variety of other things that we might be able to take advantage of through the way that business might be structured. LLCs, I've used the example of a rental property, but it also can be used to hold certain types of investment assets. And so it can provide asset protection for a variety of different things. It has tax benefits and non-tax benefits, and we've got a handout in the green folder for you to take a look at. Next, we have irrevocable trust as another tool. And these are often used to meet one of 3 different objectives: to reduce or eliminate estate tax, to reduce or eliminate income tax, or to provide asset protection. Now, I'm not going to talk about a variety. There's so many different types of irrevocable trusts. I don't have time to get into them all. I'm only going to talk about a couple of them. I want to start with a domestic asset protection trust. This type of trust I like a lot because very often when we're doing estate tax avoidance planning, I have to tell the client, well, sadly, you own too much money. It's a nice problem to have, but what we have to do is give some of that away. And of course, a client's going to say, you know what, I don't want to give it away. I want to keep it for my own needs. What if I need it? Well, a domestic asset protection trust is a tool that you can use to give assets away to yourself. Our tax code has a provision in it that says if you give to a certain type of irrevocable trust, it can be excluded from your state. You might have to file a gift tax return, but you've got a $12 million exemption. So what if you use $1 million of it to give something away now? You don't own it later when it comes time for your passing. It's outside of your estate. That can be a great benefit. So we use this maybe with a bond portfolio or something that's not going to appreciate, and we can get assets out of your estate so that you don't have a taxable estate. If we can fill it up with enough so that you only have the $1 million that's left at your death. And it's protected from the claims of potential future creditors. If you have somebody out there that you know has a claim against you, it does not protect you from those claims. We have to look to some of the states that allow you to use these. And I don't have them all memorized, but some of the states include places like Nevada, South Dakota, Alaska, Delaware, New Hampshire, Rhode Island, Virginia, Ohio, Tennessee, Mississippi, Hawaii, and there's a few I'm not remembering at the moment. But each of these states allow you to create a trust for yourself. There are rules that you have to follow. you have to have a trustee located in the state whose law you're using to create this trust. All right? Now, Massachusetts and Florida don't recognize this trust. In fact, Massachusetts recently had a case that said these types of concept where you create a trust to make an asset not available to your own creditors is against our public policy. We don't recognize these. So you don't put Massachusetts real estate into one of these trusts, but you can put investments, and you have to have, as I said, a trustee in one of the states that recognizes these. So very often that means you're going to pick a professional trustee in a state that lets you do this. Now, these professional trustees charge a fee, but it's not very expensive, and it oftentimes is a really good tool to provide two benefits of reducing your estate tax, maybe even reducing income taxes, but you definitely get the asset protection benefit. Another type of trust that's a good idea is a spousal access trust. This is Wendy's favorite type of trust, my wife who's in the back. She suggests to me that I create a trust for her. Now, do you remember earlier we had the slide with the $3 million on the top and a credit shelter slide and a credit shelter trust and a joint trust over here? We had $2 million over here. Well, what if when the first spouse was alive, instead of waiting until death to make a trust for our spouse, we do it while we're alive? We take $1 million of the 3 and put it into an irrevocable trust for our spouse. The spouse can maybe have the same rights as we talk about in our credit shelter trust. Income for life plus the right to take principal out to maintain standard of living or for medical needs or for education. So we have it so that the money's available. And there's a technique we can use that if the spouse who receives this trust dies before the spouse who creates this trust, there's a technique whereby the spouse can give it back to another trust for the benefit of the original spouse. So it's still outside of both spouses' estates. By doing this while we're alive, we're getting $1 million out of our estate. We're going to avoid estate tax. We're going to make it so it's still available for our spouse's needs and can be given back to us if we need it, if the spouse dies first. So this is a wonderful technique that you need to be aware of. This is allowed by all 50 states. All right? There are other techniques like a CUPERT and a charitable remainder trust. Charitable remainder trust is sometimes referred to as a capital gains avoidance trust. While technically it doesn't avoid the capital gain, it defers them over a long period of time. It's a way of keeping our tax bracket for capital gains in a lower level. Instead of paying 20%, we can pay 15%. Instead of being subject to the 3.8 surtax, we can spread the recognition of the gain out over a period of years to keep our income below the $250,000 level if we need to. Yeah.
Can I just ask, does an irrevocable trust mean that you can't change it until the person dies?
What it means is an irrevocable trust is a trust whereby the donor creates it and gives something to it. The asset cannot be given back to the donor, and the donor cannot have the right to amend or revoke the trust. However, I'm going to come, you know what, let me defer for just a sec. I got one more point to get to, and then I'm going to address this specifically, all right? There is a type of irrevocable trust that's very popular right now, and that's a Medicaid planning trust. So how do we avoid nursing home care? And I thought this Taylor Swift quote was a good quote to talk about this. Just because you make a good plan doesn't mean that's what's going to happen. There are a lot of people out there who are making Medicaid planning trusts. It's a good plan. It works if you need nursing home care. How many people here want to go to a nursing home? Show of hands. Nobody's raising your hand. All right. So if you don't want to go to a nursing home, why are you planning for the possibility that maybe you will go to a nursing home? It's a very popular planning technique, but it's because, yeah, it is expensive. I mean, the average cost of nursing home care right now is around $130,000 to $150,000 a year, but the average stay is a little over 2 years. So in order to make one of these types of trusts, what you have to do is create an irrevocable trust that reserves for you the right to the income, but nothing else. You can never have the right to get the principal back from that trust. If you do have that right, then the assets in the trust are available to pay for your nursing home care. It's not going to work. If you have a side agreement with your kids, hey, we'll set this up, I'll make you child one the trustee, but if I need it, you promise to give it back to me. It's not in the document, we just have this verbal agreement. If that verbal agreement exists, it's not going to work. You can't have a way to get back the principal. The principal must always be off limits. And what this does is it often makes assisted living not practical for you. If you put everything you have to start, there's this thing called a 5-year look back, where you create these trusts, put everything you own into them, wait 5 years, and now everything in the trust is protected. And then you can apply for Medicaid. But does it make sense to do that? Because you can't get access to that money back. If you put your savings account in it, what do you get back if you need it? Only the interest that the savings account can earn, which lately hasn't been a whole heck of a lot. So you want to make sure that when you do this, you're being very careful. You know what your rights are. I'm not trying to beat up on this kind of a trust. I really do want to beat up a little bit on a lot of the planners who are overselling this, in my opinion. You want to make sure that it's right for you. You need to know what your rights are. To me, and this is just my opinion, the right time to use this is once you get the diagnosis of MS, Parkinson's, dementia, Alzheimer's, something where we know you're going to end up in a nursing home. That's when we want to consider using this kind of a trust. But in the meantime, think about the cost of care and the average stay. $130,000 to $150,000 a year for a period of about 2 years, maybe a little more. So that means you're talking about maybe $300,000. Think about your total estate size. How much is your total estate worth? If you add up the value of your home, your retirement accounts, your insurances, your brokerage account, your savings, everything you own, add it all up. Does it make sense to give all of that away to save $300,000? I'm not sure. Sometimes it might make sense, but we just want to make sure it's a good idea for you. So the next thing I want to talk about is the point that you had brought up a second ago. Can an irrevocable trust be amended? So yes, our definition is an irrevocable trust is something that the donor cannot change. Now, with the exception of the Medicaid Planning Trust, I think it's a good idea to build amending methods into an irrevocable trust. And remember, your revocable trust will become irrevocable when you die, because you're not here to amend it anymore. So what happens if the kids keep the inheritance in the trust and the tax laws change? How do we fix that? So we have to build in some of the methods of amendment. The first one we have is allowed by law. We can go to court. If everybody agrees, we can petition a court and say, let's amend the trust. We can amend by agreement if the trust allows for it. State laws like Florida and California say if all the parties agree, they can just amend the trust. They don't have to go to court. So we build that into our trust document. Our revocable trusts and many of our irrevocable trusts, we allow you to amend by agreement. That can save tens of thousands of dollars in litigation costs because we won't have to go to court. We can amend the trust through something called a trust protector, if your trust has one of those. A trust protector is like a trustee on steroids. They can do things that a regular trustee can't. Finally, we have decanting. Now, I like a glass of red wine at night, so I know a little bit about decanting. You know, if you've got your bottle of red wine that you've kept in the cellar for a period of years, it might look a little dusty, might have a cobweb or two on it. You don't want to put that on your table for your guests to enjoy. So what you do is you open up the wine and you pour it into a pretty decanting bottle. And that serves two purposes. It makes the container look a little nicer, and it aerates the wine, and maybe we filter out the sediment so our guests will enjoy the contents of the old bottle better by putting it into the new bottle. By analogy, we can do the same thing with a trust. We might have an old trust document that we created 20 years ago, but tax laws have changed. So maybe we want to change the trust, but we don't have a way to amend it. So what we can do is decant it if the trust allows for us to do that. Take the assets out of the old trust, put it into a new trust document with better terms and conditions so that the beneficiaries will get more enjoyment out of it. The Kraft family first did this in Massachusetts several years ago. So now that it's Patriot season, we like to point out the Kraft family as the origin of this, all right? Now, you had asked me earlier, what about out-of-state residents? What's the estate tax consequence to them? I am often suggesting families move to a jurisdiction that doesn't have income taxes and doesn't have estate taxes, and Florida meets that definition. So I'm often suggesting to families, gee, you know, you already spend 4 months of the year in Florida. Would you mind extending that for a couple more before you come back to Massachusetts? You got to be out of Massachusetts at least 183 days of the year to say you're a resident of a state like Florida. Now, you don't have to be in Florida the whole time, you just have to be out of Massachusetts. So you can stay in Florida for 5 months, take 2 weeks to visit the kids in California, a couple of week cruise, or go to Europe, or whatever you want to do. Just be out of Massachusetts more than 183 days of the year. If you do that, that's going to change your estate tax picture significantly. So let's assume we have an estate of $1.5 million, of which there is a Massachusetts home that's worth $750,000. In order to calculate the estate tax a Florida resident would have, we have to remember for a moment, we have to forget for a moment that they're a Florida resident. We pretend they're a Mass resident to calculate what the tax would be if they were a Massachusetts resident. Now, we've got a $1.5 million estate. We can pass $1 million estate tax free. That leaves $500,000 subject to tax. 10% of that would be about $50,000. The actual number is $64,400. Now, we're going to remember that they're really a Florida resident, and we're going to build a fraction. We're going to put their Massachusetts property, their real estate and personal property located here in the Commonwealth as the numerator, and the total estate size as the denominator. So 750 over 1.5 million, that gives us a fraction of 1/2 or 50%. We'll multiply 50% times the Mass resident's estate tax and come up with the Florida resident's estate tax in this example of $32,200. Now, if your Massachusetts property is 1/4 of your total estate, you'd multiply by 25%. If it's 1/3 of your total estate, you'd multiply by 33.33%. So you get the idea of how you do this exercise, but this will give you an idea of what the tax liability is. Can we eliminate that? Absolutely. There's a couple of easy things. One doesn't require anything on the screen. If you use our joint trust, and if the net value of your Massachusetts real estate is less than $1 million, now I say net value. In other words, if you have it owned by your trust and there's a mortgage against it, and the total value after the mortgage is below $1 million, we can put that Massachusetts property into the credit shelter trust that was on the far side of the screen in that $3 million example. We can allocate it to that at the first death. Now we don't have any Massachusetts real estate when the surviving spouse dies. We have 0 estate tax. Really simple. We do this all the time for our clients. It's a great technique to eliminate the estate tax. If our estate is larger than that, we have a very valuable piece of real estate, or we have a lot of rental property, we may look at some of these other techniques. Common one is to use an LLC. If you've got rental properties out there, an LLC is probably the strongest asset protection technique you can have to make sure that your tenants can't reach through to get to your other stuff. So, maybe we want to organize LLCs to own those. Now, you don't own real estate in Massachusetts. Instead, you own a business, and the business happens to own real estate. So arguably, you're not subject to the Massachusetts estate tax anymore because you've converted this to an LLC rather than to a property held by a trust. All right? All right, so then we've got a final quote for you today, and I love Yogi Berra quotes. You got to get the humor of these. If you don't know where you're going, you'll end up someplace else. So, I think that's really true, especially when it comes to estate planning. How will you know where you're going? I hope you got some good information from our seminar today. There's a lot that I've thrown out at you. We've tried to give you some of the basics, some of the more sophisticated techniques, some of the other things that you can do to reduce estate tax and provide for asset protection. I think maybe you've found that perhaps there's something missing in the plan that you have, or maybe there's something that's not quite right with the plan that you have. So I'd encourage you to take the next step. The first step was learning. The second step is seeing how you can apply. So consider signing up for a free consultation with myself or Whitney at my firm. We've got the 2 lawyers that you can meet with. Come in for a free consultation. It's not a sales pitch. We simply want to meet with you to see if any of these techniques can work for you. And I'd encourage you to not procrastinate. It's easy to want to put this stuff off, and I understand why. Nobody wants to contemplate their own mortality. But really what we want to do is just structure things so that it will work easily and efficiently so that if there is a death or an incapacity, you're going to get the right result. I'm often asked what's the cost of an estate plan, and we've shopped around a little bit, looked at what some of our competitors charge. Today we're going to find that a basic estate plan that does some of the things that I've talked about, probate avoidance, estate tax reduction, for a couple it's generally going to run around $7,500. It's maybe $6,000 or so, but somewhere in that neighborhood. It doesn't have the contractor plan, it won't have asset protection, it won't have the IRA trust, doesn't include beneficiary designations, and getting some of the features by added through irrevocable trust that you might be able to structure to do some of these other features is going to cost you more. So to do some of the things we've talked about, we think our competitors would be charging somewhere around $11,000 to $12,000. Our costs are significantly less than that. To do the basic estate plan that would include the contractor plan and a homestead declaration, it's 2 payments of $3,100. If you want to add the asset protection feature of the personal asset trust, it's 2 payments of $500. And finally, if you wanted to add the IRA inheritance trust, it's 2 more payments of $600. Total cost would be around $8,400, but for listening to me drone on for the last couple of hours talking about death and taxes, you get the chance to reduce that fee if you're interested. If you sign up for a free consultation today before you leave, we'll give you a discount coupon of $300 so you can reduce the cost of the estate plan.
What's a K2 plan?
A contract, K is an abbreviation for a contract. I'm sorry, yeah, and I was running out of room on the slide. So K2 plan, contract 2 plan is what I was trying to get to. All right, so we've got another handout that I believe you have in your green folder is a little summary of the benefits of using the personal asset trust. And if you look through all of this, our plan versus our competitor's plan, the first couple of things we both do. Avoid estate tax, avoid probate. That has a lot of value just in and of itself. But when you start looking at some of these other things like reducing the income tax cost, making sure that there's no inheritance tax on the assets that the kids inherit, trying to do these types of things, we feel the total value of everything you're getting with a personal asset trust can amount to somewhere around $650,000 to your heirs. That's a heck of a lot of value by adding $1,000 or $2,200 of additional planning to your estate plan. You're getting a lot of return for your dollar. If the type of plan I've been talking about so far is overkill for you, you really want to keep it simple, you just want a simple trust, you want to avoid probate, you want to have a tool to reduce estate taxes, we have a simplified trust plan. It's 2 payments of $1,800. Again, for signing up for a conference today, we get you to reduce that cost by $300, brings it down to a total of $3,300. So know that's out there as well. Before you leave today, if everybody would just take a couple of minutes and fill out this form. If you're interested in the free consultation that's offered by Asset Management Resources, you got a folder from them as well. If you're interested in that free consultation, they'll sit down with you, they'll look at your investment goals and objectives, your risk tolerance, look at your portfolio, and try to point out the good points and maybe some risks that you might be taking you may not want, and where you might be able to reduce that risk and maybe get a better result. If you're interested in that, just up in the top corner underneath location, add you'd like to meet with AMR. We'll give a copy of this form to them and they'll reach out to you to schedule a consultation at your convenience. All right. As far as our part of the equation goes, if you're interested in that free consultation, talk to Wendy, or you can call the office at 508-775-7800 to schedule a complimentary consultation. We give you the $300 discount if you sign up before you leave today, so please consider doing that. Fill this out if you've got any questions or if you've got suggestions, if I didn't cover something you were expecting or if you have some constructive criticism, please feel free to add that to the back of the form. There's some room on the back. I'd also greatly appreciate if you'd consider writing a review on Google. If you liked what you heard today, please go on to the Google My Business page for Boyd & Boyd PC and give us a nice 5-star rating. It's going to help other people find us and our seminars, whether it's here in person or on our website. We have a lot of different seminars available on our website, but that review will certainly help others find us as well. If you do have a negative comment, I do want to know it, but I'd ask you not to post it on Google. Please just feel free to shoot me an email or convey that to me before you leave or some other method. I want to know if you have constructive criticism. I'd love to hear it and try to improve things. Finally, if you know of anybody, we still have a seminar left at the Wachusett. If you think somebody might benefit from attending our seminar, we've got one more of these left this season, so please pass the word on. I'd like to thank everybody for your time and attention this morning. I appreciate that you were here. I hope you got some good information. I hope you had a chance to learn a lot. I appreciate all the questions. We had some really good questions today. Thank you. And I do hope that you'll let our family help your family. Have a wonderful day.